Are here for sentencing following the entry of guilty pleas on February 1st to two of these three charges. Count 1, first-degree recklessly endangering safety, which is a Class F felony, and Count 2, felony bail jumping, which is a Class H felony. Count 3 was dismissed but read in for the purposes of sentencing. A pre-sentence investigation was prepared. That was filed on March 13th, 2024. Has the state had an opportunity to review that?
Yes.
And do you have any corrections, additions, deletions, anything?
No.
All right. Mr. Webb, on behalf of your client, have you had an opportunity to review it and go over it with him?
I have.
And are there any additions, changes, anything?
No.
All right. I have additionally read the victim impact statement and restitution request from the named victim JT, and as well as a number of letters of support. I think one was a duplicate, but letters of support filed on behalf of Mr. Jinor-Riley. I believe we're ready to begin with the sentencing, so I'll hear from the state first.
Regarding the restitution request, defense counsel and I have come up with a stipulation, and it's my understanding that the defendant is going to stipulate to paying $8,000 in restitution.
Is that correct, Mr. Webb?
That is correct.
All right.
The state's recommendation is prison to the court. Before I give my sentencing argument, I would ask that the court listen to statements that now Detective Justin Torres-Rios would like to inform you of.
All right, Detective. You can say it from there. Just state and spell your name for the record, please.
I'll be detective in a couple of months, but Officer Justin Torres-Rios, JUSTIN-TORRES. Supposed to read this? All right. Thank you, everybody, for being here. Thank you for allowing me to say what I needed to say. Your Honor, I know that you read the statement that I wrote. First and foremost, I also want to thank God for being here. I know not many people get the opportunity to speak when it comes to these situations, but I feel the actions of Timothy Jinor-Riley were criminally reckless. Timothy Jinor-Riley intentionally drove a 3,000-pound vehicle directly into me, showing an utter disregard for my life. Timothy was aiding a fleeing felon and not in fear for his life when he tried to kill me. I feel Timothy showed no remorse and would do it again, not only to me, but anyone living in society. This action has forced me into a position that I've never been in, never wanted to be in. Due to Timothy attempting to kill me at the time, I felt weak, physically and mentally. This event has scared my entire family and myself. I was put on administrative duty for 3 months, causing me to lose thousands of dollars. This monetary loss has affected my payments to sustain my family's life and provide for my, at the time, 7-month-old child. This event has caused great emotional stress in my relationship with the mother of my child due to her knowing I might never come home and be with her or my child after leaving for my tour of duty. I would take off of work using my own comp time, compensatory time, or FMLA, or sick days due to the need for rest due to the lingering pain in my lower back. This event has caused a major increase of stress in my life. For example, I now stress eat and I had to stop my routine of going to the gym due to the physical pain that I feel every day. I am now attempting to return to the gym, and I'm going through physical therapy in order to help deal with my severe back pain. I have been unable to sleep at night due to flashbacks of the incident, and at other times my back pain would just keep me awake. This has most importantly affected how I play with my child. I'm no longer able to play with my child how I used to. I'm afraid to pick up my child at times due to how sharp and severe my lower back pain can be from this incident. Due to this incident, I feel a sharp knife-like stabbing pain in my lower back when I attempt to pick her up, or if I move too quickly, I have to watch my child raise her arms wondering why her dad can't pick her up, but everybody else can so quickly. I would like to see Timothy serve the time that he's supposed to serve, whether it's the maximum time, so that he may reflect on his actions and to understand that life is precious for everybody. I hope to see Timothy rehabilitate after his sentence, and I pray that he reflects on his life choices as he serves his time. I will continue to feel the physical, emotional, and financial impact for years to come. I know this is not the first felony Timothy has committed, and it is time that he is held accountable for his actions. I would like to see the court order Timothy to pay restitution, as was discussed. Thank you.
Thank you for making your statement.
I will have some video to show the court. Not quite yet, but I'll let you know when that's the case. So I'd start out by noting that the defendant does not have a prior record. This is his first set of convictions. He does have another open case, and that's a pending matter in 22 CF 4979. The charge is possession with intent to deliver marijuana, 200 to 1,000 grams, party to a crime. His initial appearance was in response to a summons on February 3rd, 2023. On that date, he was released with a signature bond. I would note that the offense date and the arrest date was from December 18th, 2022. He posted $3,000 cash before charges were issued on December 21st, 2022. The complaint was filed on December 23rd, 2022. After he went through initial appearance court on February 3rd, 2023, a preliminary hearing was set for February 9th, 2023. He failed to appear for that preliminary hearing and went into warrant status until his arrest in this offense. So the defendant was in fugitive status. He had an open bench warrant for his arrest at the time of this offense, and I think that that is very relevant to what occurred. The case that he has pending still, and I'm just going to talk about it briefly. I recognize that these are allegations only. However, I think that his associations with other individuals in both that case and the current case are part of what is concerning to the state in terms of his criminal actions and what he would do in the future. The 2022 case stemmed from an arrest operation on December 18th, where law enforcement were looking for an individual named James Baemert, B-A-E-M-M-E-R-T, who was wanted for possession of a machine gun. Law enforcement see him at a residence and gain consent to enter that residence. Baemert is with two other individuals, the defendant being one, as well as an individual named Tavion Powell, T-A-Y-V-I-O-N, Powell. Tavion Powell and James Baemert are and have been identified as associates of a juvenile group identified as the Get Back Gang, or GBG. They are associates of that group. That group has been in an ongoing feud with other juvenile groups throughout Milwaukee over the past few years. I think that this court may preside over several cases where investigations have stemmed from these feuding groups. The Get Back Gang has been involved in non-fatal shootings, homicides, and shots fired. I don't know what the defendant's relationship to the Get Back Gang is, other than his association to Baemert and Powell in this particular December 18th incident. But again, these are associations or relationships that are a cause for concern. In the case that he's got open, it involved quantity of marijuana that was recovered, along with indicia of distribution, and it involved the recovery of multiple firearms, semi-automatic firearms in that residence as well. He is charged with possession with intent to deliver marijuana, not the firearms, but I think it's important to note that firearms were found in that residence as well. Moving on to the current case and associations that he has, he was with an individual named Ramon Trujillo, Trujillo. Ramon Trujillo has been identified as an associate of a group called FNF or Fire Batch. They're involved with a feud with another group in Milwaukee. On August 25th, 2023, Trujillo had 3 open bench warrants stemming from 3 open felony cases. His charges involved felon in possession, fleeing, possession with intent to deliver cocaine, and he was in warrant status as well. Law enforcement on August 25th were looking for Trujillo. Law enforcement here and Officer Torres Rios are part of an FBI MPD joint task force, and they specifically were looking for Trujillo on the day of August 25th, 2023. I know that the court's read the complaint. I think what is important at the outset is to have the court review the video in this case. I'm going to show the court 2 videos. One is surveillance footage from another building that overlooks the parking lot of the Fairfield Inn and Suites where this happened. And then the other is going to be Officer Torres Rios's body-worn camera. I'm going to show both videos in full speed and then also do them in slow motion.
Okay, I'm going to come down and sit there because it helps me see it better.
And just for some additional context, the Fairfield Inn and Suites is located at 7035 North Port Washington Road in Glendale. Law enforcement knew that the vehicle associated with Trujillo was at this location. They set up surveillance in an effort to locate and arrest Trujillo. They ultimately see Trujillo walking with this defendant and a third individual. You're going to see them coming from the right side of the building as it's depicted on the screen.
Okay, hold on.
I haven't plugged it in yet.
Oh, it's not plugged in. Okay.
And for the record, this is at 47:50 on the timer. So you're going to look at the kind of the middle right-hand side of the screen. 3 individuals are going to come walking from that side of the hotel, and there's a black sedan that's just off view of the screen. There's going to be a law enforcement undercover pickup truck that enters into the parking lot at the bottom of the screen. I stopped that at 48 minutes and 39 seconds. I am going to return to the original time and play this in slow motion. And I would just ask that you pay attention to how the pickup truck, the undercover police vehicle, is rocked back and forth as the defendant drives the sedan into it. So you can very clearly see that Officer Torres Rios is getting out of that undercover vehicle in order to effectuate an arrest. And the defendant plows right into him. Whether he thinks that he's able to make that turn, as he indicates in his PSI statements, the officer is right there. He had just gotten out. He is literally right in front of the vehicle when the defendant drives right into him. You'll see in the body cam that the front bumper of that sedan is ripped off in the process of hitting the undercover vehicle. And that's not just a mild striking of the undercover truck. That truck rocks back and forth, and Officer Torres Rios with it. I'm going to then play the body camera. And that's going to be starting at 30 seconds. There is audio to this.
You good?
Shots fired, shots fired.
Shots fired. You good?
Yeah. Yeah, I'm good.
What do you need? What do you need?
I'm good.
You hit?
Yeah, he fucking ran right into me.
Where?
Ah, fuck.
Here, put the gun away.
Okay?
I got it.
Put your gun here. Give me your gun. Give me your gun. Are you okay?
Where you hit?
Yeah, no, I'm not hit, man. I shot into the car.
Okay, no, are you okay?
Yeah, he smashed into my legs, dude.
Okay, sit down. Sit here. Sit down. Fuck. Just sit. Sit all the way. Sit okay. Are you having a hard time breathing at all?
Nah,
I got it.
Can you get him in the ambulance?
I got it. You got struck.
He got fucking.
he got hit by the car.
He got hit by the car.
I got it.
fuck, man.
Are you bleeding anywhere?
Nah, I'm good, bro. I'm good.
Where's your holster, brother?
I'm good. That's right here.
I'm just gonna unload this quick, okay?
Yeah.
I'm just gonna sit it here.
Seconds, but play it in slow motion. that the defendant was driving. Officer Torres Rios did discharge his firearm, and rounds hit both the defendant and Mr. Trujillo. They sustained gunshot wounds through this. That vehicle was ultimately stopped just on the other side of that parking lot, so they did not get far. However, this is a clear effort to evade police and do whatever he thought he needed to do to get away from law enforcement and away from accepting responsibility. That undercover truck was damaged in the process as well. I can tell the court that during a search of the vehicle, under the front driver's seat was a Glock pistol. That firearm is pending DNA testing. I don't have the results at this point, but that has been sent out for DNA testing. The defendant made a statement. He identified that he had been staying at that hotel with Trujillo for the preceding 4 nights, that he was suspicious leading up to walking out of the hotel because he had seen people taking pictures. He noticed that there were a lot of vehicles and thought that was strange. In his Mirandized statement, he said he got halfway to the vehicle and heard, "Don't move, don't move." He admitted that he knew it was the police and that he knew that he had a bench warrant, that he did not want to go to jail, so he continued to the vehicle and fled. He indicated that Trujillo got in the front passenger seat. He stated that there was a truck in front of him and that he sideswiped it. He indicated that, again, he knew it was the police when he decided to flee. And in his Mirandized statement, he says that he did not see the officer standing outside the truck, nor was he intentionally trying to hit the vehicle, that he simply did not see another route to flee. That video there, he's got absolutely no clearance to make that turn. I don't know how anyone in his position could not have seen Officer Torres Rios standing very clearly outside the driver's door, or the door of that vehicle. Jinor-Riley in his Mirandized interview denied knowing that the gun was under the driver's seat. However, he admitted to touching it a few days prior. And when asked if he could go back in time, knowing the outcome now, he said he still would have fled. And he would have fled because he didn't want to go to jail for his bench warrant. That's consistent, I think, with the information that he provides in the PSI. You know, his statement to the PSI, particularly the statement that he says the door closed on the officer's foot, trapping it in between the door and the bottom of the frame of the car. And the comment, "I'm sure he went to the hospital to get it checked out, but beyond maybe some pain and some bruising, he was not severely injured." I think that's a very offensive statement. I think it mitigates what he did. I think he's trying to minimize his conduct. I think he lacks appreciation for the seriousness of his actions and the impact that his actions had and still have on Officer Torres Rios. To say that that's all that happened when the video clearly shows something different is offensive, in my opinion. He also talks about the fact that he took some Percocet and smoked marijuana just prior to leaving the hotel room. So he's also driving while intoxicated, on top of the fact that he doesn't have a driver's license, so he shouldn't be driving, period. These were a series of incredibly dangerous and poor decisions. Not to mention that not only does he have an open arrest warrant, but the person that he's with has one too. And if I had to guess, also impacted his decision to flee. I think he's got a lack of understanding of what his decision-making has caused for Officer Torres Rios. And I think it's fortunate that Officer Torres Rios was not hurt more. The sentencing goals for this type of crime has to be with an element of punishment. It has to be with an overarching goal of protection of the community and deterrence, specifically for this defendant and the deterrence of others. I think underlying this case is the overarching idea or a mentality that you can flee from the police. And this is an overarching lack of respect for law enforcement and the lack of willingness to accept responsibility that we're seeing so much of in Wisconsin, in Milwaukee. You've got an open warrant, you've got drugs, you've got a gun. Why not just flee from law enforcement? Why not just flee from police in order to attempt to get out of accepting responsibility or to stop law enforcement from catching you? Fleeing from police has become all too common in the last few years. It results in property damage, it results in injury, and it results in death. I recognize that the defendant didn't make it very far, but that's what he was doing. That was his mentality. I'm just going to flee. This mentality robs people of a sense of security in their commutes home from work, when driving with their families. It forces law-abiding citizens to worry about something that they should never have to worry about. And in this case, and I would argue in every case where someone flees from law enforcement, it puts law enforcement in danger. And this is exactly an example of how it does so. It puts officers who are on the street going to work every day to try to protect this community, knowing how dangerous these fleeing vehicles are, and they know that, and they still go out there and do their jobs, knowing that it's the right thing to do, despite the fact that this is an all too common tactic used by wanted individuals to employ evading arrest. So the defendant is somebody who's willing to flee. He knows he's got an arrest warrant. He's been out on that arrest warrant for over 6 months, which I think is a long time to be in arrest warrant status. He clearly does not want to go to jail. He's used drugs. He doesn't have a driver's license. And he wants to get away. The person he's with 3 open warrants, arguably wants to get away. He knows that the police are there and he's doing whatever he can to get away. He's not even close to clearing that truck, and Officer Torres Rios was very clearly right in front of him, standing right in front of that vehicle. The defendant just plows right into him. What's resulted is that Officer Rios's life has changed. He's got ongoing pain and ongoing injury, and has had to make decisions that have been a direct result of the defendant's actions. Because of all of that, the state's requesting that the defendant be sentenced to a period in prison. Thank you.
Thank you. Mr. Webb?
Your Honor, before I make my sentencing argument, my client's sister is prepared to make a statement to the court.
All right, you may come up. You can have a seat right there. You can speak right into the microphone. Please state and spell your name, and then you may make your statement.
Hi, Your Honor. My name is Taylor Jinor-Riley, and today I will be speaking on the behalf of Timothy. I want to start out by stating what I believe put him in this predicament. He's a very generous person, and he's a helping hand to many of people in his life. He has a big heart, and he's a people person. Him having these traits, I believe, led him to a path where he's has misled trust. I'm sorry.
It's okay.
Him having these traits knocked him into a path that has brought him to having misled trust in people that he does not recognize and loyalty. Prior to him heading in this path, we both set goals and plans to move to Houston, Texas, to go hand in hand starting a business after I graduate this year. I be planning to become a realtor, and he would be the contractor of our business to eventually own and sell properties. Timothy has very good knowledge and experience of building projects and fixing homes. And like the officer said, his family has been affected, and ours has been affected too. Knowing that Tim was put in harm's way by being shot, and he has been absent for almost 9 months of our lives. So today I am here hoping that you would consider his life goals and give him a chance to redeem himself for the decisions he has made. Thank you.
Okay, thank you for making your statement.
Mr. Riley has prepared a written statement for the court that he would like to read.
Okay.
Dear Judge Michelle Havis, as I, Timothy Jinor-Riley, sit here before you today, a changed young man, I accept all responsibility for all my actions. I made a lot of mistakes. Some are bigger than others. I'm not just here to blame my wrongdoings on nobody else. I'm not here to seem innocent. I'm here today to apologize, not only to all the people that have been hurt, but to my parents. And Officer Torres and the DA in this situation. Your Honor, I was not aware. Your Honor, I was raised in a two-parent household. I was taught right from wrong. I chose being around the wrong people, which later led me to bring me down, which later on caused me to make poor decisions and choices, Your Honor. I also grew from them now, but my parents always told me, don't end up like the people you hang around. And look here today, what it led to today, me here. I put not only my life, but everyone that love and care for me, life on pause. But I'm forever thankful for that no one was here, no one was seriously injured / killed in this situation. Your Honor, I wasn't aware that the incident was going to take place. I have not been through something like that ever in my life. I wasn't in the right state of mind, so I quickly panicked, which led me to make the wrong, which caused me to make the wrong decision. I understand what I did was a mistake, but yes, I should be held accountable for my actions, Your Honor. Me saying what drugs can make me do, make me not want to take them anymore. I used this long 7 months to cleanse myself from all of those kinds of choices and things. I'm a better man, I feel now, Your Honor. I go to Bible studies every Saturday to get closer with the Lord. And when I'm alone in my cell every day, I pray and ask for forgiveness, Your Honor. Even if no one see me a changed man, I see and feel that I changed a lot, Your Honor.
Thank you.
Your Honor, there's things that we disagree with as it relates to what the court clearly saw in the video. But it doesn't change the reality of three important things that I think the court has to consider. Perception of what did or did not occur, and as Mr. Riley put in his statement, thank God that the officer who's about to become a detective was not at that moment killed or receive any broken bones or torn sort of things. And when Mr. Riley indicates that particular reality, because those things weren't present in the discovery, that isn't a statement of lack of understanding, but a statement as it relates to what he knows the response was. As if the court looks at his full statement in the PSI of what he was attempting not to do. He was not driving, trying to T-bone a car. As the state correctly indicated, and as we discussed throughout the pendency of this case, there was not an appropriate level of clearance to try to turn a wheel. But what was not present was an attempt to T-bone a car or T-bone the truck. That places Mr. Riley Joyner, as this court is well aware and the state is well aware, will place us in a completely different sort of scenario as to what someone's intent would be and what the outcome that one is trying to accomplish. It does not, as Mr. Riley Joyner stated throughout his statement that he wrote and as in his statement in the PSI, he has never ever tried to obfuscate his level of responsibility. He's indicated throughout the time when he was arrested that he was responsible. At the time when he took the plea, he indicated his responsibility. Through the PSI, he stated his responsibility, and here today, he continued to use the word, I am accountable for my choices and my actions. He stated clearly in the PSI, as well as in his written statement to this court, his choices of who he was with were his choices. And I think it's important because the state went through and indicated, well, we don't know if he's part of GBG or one of these other street gangs. As this court is well aware, I've represented people from all of those organizations. I currently have pending in homicide courts someone that was in the opposite gang. So all the memberships of who's with who is clearly in my discovery box in different cases. And Mr. Riley Joyner was never associated in any of those street gangs, being that of the Wild 100s or the GBGs or any other street gang, based upon the level of discovery that I've reviewed and the officers who I've had a chance to talk to, as well as the homicide detectives. But what I think is clear, as his sister indicated, in each one of these two situations that he has, one pending case and now the one that he pled to, Mr. Riley Joyner was not the target of what the police were going to look for. As the state recited in the other case, they were looking for two other GBG gang members who were involved in having weapons and things of that nature. And Mr. Riley Joyner wasn't charged with that. In this particular situation, they were looking for Mr. Torrio, who had 3 open warrants, who was the person who they were out looking for. His choices, as he indicated and he wrote in this statement clearly, is what his parents warned him of. Who you keep company with defines the choices that you make. And he says, as I sit here today, they are so right because that choice of who I chose to be with placed me in this situation. In each one of these scenarios, Mr. Riley Joyner is the individual who's going to take the brunt of his choices for his decisions to be associated. And it all centers around poor choices, but more importantly, how the effects of using mood-altering substances, these drugs that young people are involved with, that are removing proper decisions. You're looking at someone who's 19, 20 years of age, who's not fully developed, who does not fully appreciate those things. And the science is clear about how we develop as human beings and how long it takes us to be able to make those rational sort of choices that one needs to make. That does not excuse his behavior. It places it into the context. And Mr. Riley Joyner indicated exactly his decisions, his level of culpability places him here today. He is 21 years of age. This year I believe his date of birth is in May, if I'm not mistaken. He'll be 21, so he's 20 right now. He's been in custody now 208 days prior to today's date that he's entitled to pretrial incarceration. I reviewed the video with my client. I reviewed it with the state. We've had discussions as it relates to what in the heck were you thinking? The entire parking lot, as we see in the video, there's officers everywhere. The pathway is not clear to go anywhere. As he said to me, and as I've indicated here, thank God no one died on this date, including Mr. Riley Joyner. As the officer indicated, I fired a couple times underneath the car. Mr. Torrio was hit. Mr. Riley Joyner was hit. Based upon this fact of trying to get away and turning that car and trying to get away. That placed this officer in danger. But I think it's important that as you review that video, that the notion that he was trying to ram the vehicle directly on, we disagree with. But it does not change his culpability as he's indicated. He's not trying to ram anything. That's my opinion as I look at that video. There's no clearance, there's no way to get away, but he's not ramming into a vehicle, trying to back up and ram back into a vehicle at that point. But the harm that he caused is clear. We heard the statement. There is no disagreement as it relates to that. And the reason why there's no disagreement, Mr. Riley Joyner is taking responsibility by stipulating to the request and restitution, by taking the level of responsibility. We've always were in a posture of resolution. It takes time, as this court is aware, for the state to be able to speak when we make a counteroffer to try to resolve these cases. And the court gave us an opportunity to do that. So at the earliest opportunity, we put this on a track of resolution. There was no trial date set. There was no obfuscation by Mr. Jinor-Riley to try to say anything other than I am accountable for my actions. The state has correctly indicated what are the 3 sentencing goals. But I also like to remind the court of the first principle that the Court of Appeals and the Supreme Court has indicated that the court has to rely upon, is the least restrictive sentence to accomplish a goal. A maximum sentence is per se unreasonable unless the facts and circumstances overcomes that and indicates that that is warranted. It is our position, as well as my position, that a period of confinement that my client is aware of is going to be ordered by this court. There's not a disagreement in our mind or Mr. Jinor-Riley that the court is not going to impose a prison term. We're not suggesting that you should not. So we're not suggesting that a period of probation is warranted based upon the facts and circumstances here. However, a maximum sentence, in our estimation, is not warranted under the facts and circumstances as it existed at this point, my client's level of responsibility, his lack of a criminal record, and some important things that you found out in this PSI. His parents worked hard to be able to send him to a private school where he maintained a solid B to a B plus average. He had an 85% GPA from what I saw.
Nope, 0.855 or 0.885. I assume that's on a 4-point scale.
Was that below 1?
He only has 30 out of his 50 credits, and he was a senior.
My understanding from what he describes to me was being only a couple credit hours short. Again, I did not pull his school records as it relates to that, Your Honor.
Okay.
But he continued to go to that private school. He was there. He's come from a two family unit. He's been able to work consistently throughout, and I was able to observe some of his work when I went to his mother's residence on the home interior work that he's done. When I was retained, I was able to see a lot of the home improvement work that he did inside of the residence, as well as other work that he's done based upon photographs that I've seen when he had an opportunity to work with his father as well as his grandfather, as far as being able to do carpentry and other related skills. I find his sister to be very impressive and what her ultimate life goals are and what she's been able to obtain and where she's going. And that is in direct reflection of the love and care that the folks that are sitting in this courtroom have provided to Mr. Riley Joyner. This community is aware of the value that he provides us, but also acknowledges that he made some poor choices. And those poor choices leads him here. You've had a chance to review the character letters that we filed, which are the documents that I shared with the court. One of those were, and the reason why it was submitted twice, is that it was a JPEG that I received, and I was unable to get all of it in there, so I had it sent back to me in the form of a PDF by an Ingrid Webb, that's I-N-G-R-I-D Webb, who writes as it relates to who Mr. Riley Joyner is from her perspective, her level of time that she spent with him, but more importantly, she understands and is not excusing, nor has Mr. Riley Joyner attempted to excuse his culpability when he was discussing the matter with her, as well as his capacity to be better, as she spoke about his character and his value to his family. Document number 15 is written by Crystal Askew Moore. That's C-R-Y-S-T-A-A-L, Askew, A-S-K-E-W -Moore, M-O-O-R-E, who writes beautifully as it relates to who Mr. Riley Joyner is, from who she knows him to be, how positive he believes he can be in our community, as well as understanding and genuinely understanding that his decisions have affected this officer, as well as himself in the choices that he's made. Your Honor, I'm asking the court to impose a prison term not to exceed 7 years, broken down into initial confinement of 3 years of initial confinement, followed by 4 years of extended supervision, globally as it relates to both of these allegations. Mr. Jinor-Riley does not have any prior juvenile contacts. Mr. Jinor-Riley doesn't have a significant history with run-ins into the law, other than this conviction here today that he's being sentenced for and the other matter that was pending. He had been living a particular lifestyle that, in my estimation, does not warrant a maximum sentence in this particular matter. And I'm asking that the court impose a 7-year period, and for the court to seriously consider if the substance abuse program, which he is eligible for, should be meted out under the facts and circumstances of this case. Mr. Riley Joyner, in my estimation, in the time that I've represented him, has been quite respectful and willing to take responsibility, as I indicated throughout, and was looking forward to being able to provide his level of apology and his level of remorse as he expressed here today. So I would ask the court to follow our recommendation. Thank you.
All right, thank you. So whenever I sentence anyone, I need to consider 3 separate things: the gravity of the offense, the protection of the community, and the character of the defendant. I'm going to start with that character. I have a gallery. Well, I have a split gallery. I have very clearly law enforcement on one side and your family on the other. Your side is full of people who were discussed in the pre-sentence, Your sister spoke. I got the letters from the community. I have no doubt that you are everything that they say you are. No doubt whatsoever. You offered Mrs. Skewmore a ride when she needed one. You've been good to Miss Webb. She finds you respectful. And of course, your family loves you. But just as I tell people that one act does not make up the entirety of who they are, being good to people in your family also doesn't make up the entirety of who you are. And I feel, and it may have been wishful thinking during the pre-sentence investigation, so I don't blame your parents at all, when they echoed your sentiments in what I feel is minimizing what happened. They want you to be 100% the child they knew, the brother they have, the member of the community. And I find that that's probably to their detriment, because I think they haven't necessarily recognized the giant screaming signals you've been sending. When you discussed this in the pre-sentence, it was a quote. I mean, I'm sure he went to the hospital to get checked out, but beyond maybe some pain and some bruising, he was not severely injured. And this may sound glib, but I had older brothers, and on occasion, they would hit me, and then they would say, "That didn't hurt." The hitter does not get to decide whether it hurts. You do not live in that officer's body. You don't get to decide if his pain is severe or not. We all just watched that video. And we heard him, I suspect, with a lot of adrenaline running, getting out of the truck and being like, I'm good, I'm okay. And then it came. And I suspect it continues to come. I'm glad that he's getting physical therapy. I'm glad he's sounding like he's being able to get back to what he was doing. But he will likely, and this is not based on any medicine, this is just based on life experience, have some remnants of this for the rest of his life. And one of the things that I thought was interesting that your mom said is those 2 hours just completely changed his whole life. Same thing for the officer. But he didn't choose that. He wasn't in charge of whether he got rammed in that truck. I don't dispute what Mr. Webb is saying. You were trying to get the hell out of there, no question. But it was with absolutely, positively zero regard. There is no way that you didn't know he was there. That's just not at all plausible to me. And you said as much in your interview. I knew it was the police. I knew they were there. I was getting out. And if I could go back, I would do it again because I have a warrant. I don't want to go back to jail. Now, you read to me from your letter saying that you are a changed person. You are all good. You take your time, you do your Bible study, and you pray when you are alone. But similarly to how I noted that your family knows one piece of you, and this speaks to a different piece of you, you say that you're totally changed. Good to go. So you were reprimanded 16 times during your high school career. Dress code violation, possession of a cell phone. That's usual kid stuff. Can't do it, breaks the rules, but kid stuff. Disruptive behavior, disrespect, gambling, and possession of marijuana. Okay. Then I look at what they told me about how it's gone since you've been here. You told staff you weren't going to lock in your cell. You received a conduct report for being in an authorized area. You were found guilty of disobeying verbal or written orders from staff and presenting false information. Disobeying verbal or written orders from staff when you were found in a shower after being told to line up and lock in. Again, disobeying verbal or written orders. Gambling. Moving from cell to cell after being told not to. And that was on 125 and 218. And on 222, you were found guilty of verbal physical disrespect to an officer or a staff member. According to the write-up, an officer stood near your cell and overheard him say, "Shut up, bitch," or "bitch," while pretending to be asleep in bed. So I'm not sure when the change came about. Because according to your letter, this was it, this was your wake-up call. But it sounds like you're engaging in kind of the same behavior in jail as you did in high school. And turning to that high school, you said you dropped out because you had to do credit recovery. Your grade point average was .855, and you only have 30 credits of the 50 required for graduation. Now, this school must do things a little bit different. I know that's not a requirement for how credits are calculated according to the state of Wisconsin and the public school model. I think you have to have 22 for that. But for whatever it was, you needed credit recovery, so you weren't up to grade level. But you say you were going to go and you were going to go ahead and get your job back at Snap-on. And according to you, you had worked at Snap-on until July of 2023, which was just a month before this. But according to Snap-on, according to the people who were actually asked, who had your dates, they said you stopped working there in October of 22. So there's the side that says what you should be saying, and then there's the actions. Now, Mr. Webb spoke at length about your choices of hanging around with the people and I'm not taking into consideration the facts of the possession with intent to deliver THC. I want you to know I'm not doing that. It's pending in front of me. We haven't done anything substantive on it. I think I took a prelim waiver last week. But other than that, I'm not taking that into consideration except for the fact that you're out on a warrant. Okay? So I have no opinion about your guilt or innocence in that case. I'm not taking that into consideration. But the fact that you had that warrant, Mr. Webb said your choices of hanging out with the people in that first case, or Mr. Trujillo in the second case who had the warrant, are what put you in this spot. But it's really not what put you in the spot with Mr. Trujillo. and to put you in the spot this day because you had been out on a warrant for 6 months, completely and wholly independent of who you decided to be at that hotel with. You were trying to get away for you. Him coming with you might have been an added benefit as far as he was concerned, but you were trying to save yourself by saying, I don't want to go back to jail. I know I have this warrant. You just decided not to come to court, decided to keep doing what you were doing. I can imagine that it must be horrid, just horrid, to spend 6 months looking over your shoulder thinking, where, is someone following me? Am I going to get picked up on this warrant? But that's what you did. And when you did that, and when push came to shove, you got in the driver's seat. High. Had touched the gun, didn't know I don't know about the gun. But you were high, and you were the one who decided to drive. And you're saying, as I'm walking out, I'm thinking, I bet there's cops here. As a result of your choices in jumping in that car and trying to get away, his life is forever changed. And so is yours, but as I said, he didn't have any choice. You did. This is definitely not a probation case. I know your parents want it to be. It's not. I take into account the fact that you do not have any prior record. You were out on bail, but you have not been convicted of anything yet. But this was so serious. And the fact that they were looking for other people is just because they didn't know you were there. They would have been looking for you. You had a warrant. So, what I am going to do is this will be a prison sentence. I'm going to get to the numbers at the end. During the time that you were serving both as initial confinement as well as extended supervision, are you seeking a no contact order?
I didn't ask for one.
Yeah.
Not part of the negotiations.
It's a little odd given the MPD piece of it. It's hard to do that. I'm not going to issue a full-on no contact order, but I'm going to advise, don't reach out to the officer for any reason. There's no reason for that. I'm going to have you get your GED, HSED, high school diploma. It depends on where you're placed and what the program is going to be called. Your parents worked really hard to get you a good education. They were very invested in it. And it sounds like your sister is going to come through with that. I'm going to have you get whatever diploma it is, but I will also encourage you to take advantage of any educational or vocational training that you can. Use your time wisely. There's nothing that I feel is more than of a waste than someone who goes to serve a sentence and comes out none the better for it. Restitution will be set at $8,000, payable to JT. Is it JTR? Technically, JTR. That is upon stipulation of the parties. You will have 208 days sentence credit. You will have to pay the DNA surcharge as well as any mandatory cost, fees, and assessments. I'm going to waive any non-mandatory. That will be due and payable from your prison funds at a rate to be determined by the Department of Corrections. Then it will be payable as part of your extended supervision, and then it will convert to a civil judgment. As far as additional programming, I'm going to order that you have an alcohol and drug abuse assessment and comply with any treatment, that you be absolutely sober. We've discussed a lot about your choices and your judgment. That doesn't need to be altered in any way. You were already altering it, and that didn't work out. I want you to have a full mental health workup to see why it is that you've adopted some of the thought patterns that you have, and comply with any treatment that is there. I'm going to leave any other treatment needs to your agent or the Department of Corrections, who are going to get to know you much better than I could, even with the pre-sentence investigation and this argument. I am going to find that you are not eligible for the Challenge Incarceration Program, but I will find that you are eligible for the Substance Abuse Program. According to your pre-sentence and based upon your own statements, it sounds like you have a fairly extensive history of drug and alcohol abuse. I'm only the first person that makes the decision you're eligible for that program. The Department of Corrections has the final word, and they will decide. It will be after a certain period of time, and I'll get to that in a minute. But if they say no, you can't come back to the court and say, but Judge, you said. Nope, they're the final decision maker on that. You may not have any firearms, as you are now a convicted felon. I feel compelled to add to that warning to say this is something that I see over and over and over. That's never going away. You are always going to be a felon. You may never have a gun. Had you had a prior felony, you'd be looking at an additional charge of up to 10 years just for what was under the seat, because it was within your reach and control. You cannot be around guns. And I see people all the time who are living their lives and they have a gun within their control and they're going back to prison. Just get that straight in your mind right now. I can never do it. Not, I'll only do it when I'm going out. I'll only do it when I'm scared. Nope, you can't. The end. You can't vote until your civil rights are restored. You may not possess body armor. And you do have the right to appeal my sentence. And your attorney will go through those rights with you. Taking into consideration everything that I have heard in this case, I am going to sentence you as follows. On count 1, I will sentence you to 10 years in the Wisconsin State Prison, 5 years initial confinement, and 5 years extended supervision. That will be concurrent to count 2. On count 2, I will sentence you to 6 years in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. So bottom line, 5 in. You will be eligible for the substance abuse program after you've served 4 years initial confinement. I think it's a good program. I hope you're able to get in, and it may, if you would get in the first day, it might shave maybe 6 months off of your initial confinement time. But you're going to have to conform your behavior. You've not had a good track record while you've been in jail. It's not going to do you any favors to misbehave in prison and then hope you get into the earned release. So 208 days credit will be applicable to both, given that the way that I've structured the sentence, and that will be the sentence of the court. As I said, you do have the right to appeal, and Mr. Webb will go over that with you. I wish you well. I wish all of you well. Detective.